Good afternoon, Senators. My name is Fletcher Duddy. I'm an assistant public defender with the New Jersey Office of the Public Defender. I'm here this afternoon to let you know that the Office of the Public Defender opposes S-2930 substantially for the same reasons articulated by many of those who already spoke today. I don't want to repeat or belabor any of those reasons discussed again by the chorus of speakers here today, before me and likely after me. I would like to briefly make 3 points as it relates to this bill and the issue in general. Point number 1, the New Jersey Public Defender's Office is comprised of over 1,300 employees spread out over 60 offices throughout the state of New Jersey. We are one of the largest public agencies in the state, and like other public agencies, we are subject to OPRA requests. Many of those requests take up significant time and resources within the agency. There was a point where I myself was the OPRA custodian and can speak to that firsthand. These requests often required internal investigations to identify and produce those documents. We even receive requests throughout the years that may fairly be characterized as oppressive or even harassing. We've had instances, for example, like some of the other examples I heard today, in which the same requester is making multiple requests throughout the week. Yet, despite all of that, we make good on all of those OPRA requests, because the hardship that may come with processing an OPRA request is a small price to pay for government transparency, which is a principle we believe in the Public Defender's Office has always been and should be sacrosanct in the state of New Jersey. So while we share many of the same hardships and difficulties as those explained by the sponsors or the proponents of the bill, those are a small price to pay for, again, government transparency. And they don't justify the wholesale changes to the statute that's really been in existence for 60 years. A lot of the changes go back to the 1963 original iteration of this. So that's the first point I'd like to make, Senators. Secondly, the Public Defender's Office, of course, has a constitutional mandate to provide zealous, effective legal representation to indigent defendants in our state's criminal courts, appellate courts, family law courts, mental health courts, and in myriad other proceedings. Our office routinely relies on the Open Public Records Act to carry out that constitutional mandate. We use OPRA as an invaluable tool in individual client cases. We use it as a tool in broader cases of systemic impact throughout the state of New Jersey. And we use it in other issues and initiatives throughout the state to ensure that our clients are treated fairly and in accordance with their constitutional right. The examples in which we use it are really endless, but I'll highlight 3 of them, 3 just recent ones within the past couple of years alone. When several county jails, for instance, were considering closing their doors and shipping our clients across the state, far from their attorneys, their families, and the courthouses in which their cases were litigated, it was OPRA alone that helped us understand those counties' true intentions, which in turn helped us stop those closures from happening without those counties at least putting a plan in place first for attorney-client access. Another example, when we believe that a number of municipalities were not equipping their police officers with body cameras pursuant to state law, it was requests through OPRA and only OPRA that confirmed those suspicions, which then helped bring those municipalities into compliance. When staff attorneys in our family law courts were expressing concern that their juvenile clients, who were not proficient in English and were not receiving bilingual or native language rehabilitative services as a condition of probation, it was OPRA to state agencies that helped us attain policies from those agencies, helped us understand and rectify those problems. And when the Public Defender's Office believed that multiple county prosecutors were giving preferential treatment to certain groups of people charged with gun offenses, perhaps even based on race, by waiving mandatory minimum terms of imprisonment, it was OPRA requests to the Department of Corrections that assisted us in compiling data to help us rectify the issue. And this is just the tip of the iceberg. Our agency routinely relies on OPRA. There are several aspects of 2930, however, that would significantly impair our office from using OPRA as a tool to address important issues like these. I would say chief among the aspects of 2930 that would prevent this is the section, this is on page 14, subsection G, that essentially permits a denial of an OPRA request if those requests parallel other litigation. In all of the examples I gave you, all of that relates to pending litigation. Yet, of course, the OPRA requests were complied with, which helped us rectify those issues. So this section, subsection G, would very much be a dagger to the heart of what we do on a day-to-day basis. I would also point out that many of the policies that seem to have undergirded this law, the breadth of data that's now being mined well into the 21st century, the commercialization of OPRA, the unusual, if not creepy requests. I don't see how preventing OPRA requests that may also bear on pending litigation speaks to any of those underlying policy concerns. There seems to be a disconnect there. Another issue that the agency takes with the current iteration of the statute is the provision that essentially delays the start of the OPRA clock until the custodian has received the request. Another one is the provision that allows the OPRA custodian to deny the request if he or she believes it may be harassing or could lead to harassment. You know, what one's definition of harassment may be completely different from another person's definition of harassment is. So these are just some of the concerns that the agency has, senators, and because of those concerns, we oppose the bill. Third and finally, the third and final comment we have, and this relates to, this is towards the, understood, Mr. Chairperson. This is the final point I'll make. So this relates to...
I just want to make sure everybody's getting late in the day. I want to make sure we have a chance. So.
Understood. So the current iteration of the bill envisions a 12-person task force, which is established to recommend changes which ostensibly seem to broaden access to police records. However, we have concerns that the membership is highly skewed toward law enforcement or other government agencies like counties or municipal officials that may have a vested interest in protecting the very records that belong to their agencies. And so we would recommend broadening that membership to include other criminal defense attorneys and public defenders. And so thank you again for giving me the time, Mr. Chairperson, senators. I'm happy to answer any questions you may have.
As you know, there's no police records as part of this bill. We're not impacting police records as part of this bill.
Well, the bill creates a task
force.
Right.
Public defenders on the list.
There's only one slot for either a private attorney or a public defender. There should be a public defender, member of the private bar, perhaps from the state bar or association of criminal defense lawyers.
Thank you.
Thank you.